90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. We're continuing our series about COVID in the courts and how the courts are changed in response to COVID and to keep litigation and resolution of cases moving. The latest development in that is using ADR in the courts itself. And our guest today is Yvonne Marin, and she is the ADR, which stands for Alternate Dispute Resolution Coordinator for the 10th Judicial District, which is Nassau County. She is also a court attorney and referee.
Hi,
welcome to Law You Should Know.
Hi, thank you for having me.
I'm hoping you can educate the attorneys out there and also litigants and the general public about how the courts are trying to keep in the business of resolving disputes, although we may not have access to jury trials, and taking advantage of alternate dispute resolution to move disputes along and resolve them so that they don't back up and litigants have their day in court. So what are your how are courts now encouraging ADR because of COVID? Well,
the ADR actually didn't start just because of COVID. It was an initiative that started with the Chief Judge's Excellence Initiative, and that goes back to 2018 when she started a statewide committee to do an investigation as to what the utilization of ADR in the courts and the benefits. And in early 2019, the Chief Judge announced that at that point, she felt that the time was right to provide litigants and lawyers with a broader range of options without a high monetary cost, emotional cost. So ADR has been something that has been, even before COVID, was in the works, and we were developing programs. So by the end of 2018, come 2019 actually, the courts were putting in place ADR programs, and those were court-sponsored programs to offer some sort of ADR to litigants early on in the life of the case.
So a case may, under ordinary times might take 2 or 3 or 4 years from the time it was initiated to the time it was resolved. Your ADR can almost kick in on day one so that a dispute could be resolved in its infancy or within a few months after it reaches the courthouse.
Exactly, because the reality of the situation was that only a small percentage, if say 5% of cases, were actually going to trial. But these cases were settling at some point in the life of the case, but usually it was later on after discovery, after the case had been on the books for several years, and possibly during jury selection when they actually have the jurors sitting there picking jurors, or after they've been selected and they're just about to go to trial. That's when the parties really sat down with the judge and tried to settle the case. So the theory is that because these cases are settling, there's no need to wait years and have the costs increase and the positions harden between the parties. That ADR or settlement of the case is something that should be brought up, and if it's brought up by the court, it kind of has a different feeling to the parties. Perhaps they're more encouraged to discuss it as opposed to them bringing it up on their own.
So fast forwarding to the age of COVID and beyond, what will the new procedures be once a case is initiated? Let's say a contract action, a tort lawsuit, or perhaps even a matrimonial case.
Okay, so we have in place certain case-specific ADR options. But across the board, all the judges are constantly bringing up the issue of settlement, of ADR, and, constantly revisiting that issue. So that's a change that definitely, and also because the judges are available, they're not in-person activity is not, going on to high level, judges are conducting settlement conferences on their own. But in terms of specifically with respect to case types, each court has different programs. For example, we have some larger programs with respect to the commercial division cases and commercial matters in general. So even though the commercial division handles cases that are over I think the threshold is $200,000, any commercial case can go to our ADR program. We have a roster of mediators, highly qualified commercial mediators. They will provide 4 hours of free mediation, and thereafter, if they want to continue with the mediation sessions beyond the initial session, they can pay $500 an hour. And this is a program that the parties can consent to going into the program and having their case resolved through ADR, or the court can refer them to this program. But a great part is that, the parties have the opportunity to select a neutral from the roster themselves. So that's one of the programs.
Will be the same neutral that continues to oversee the mediation and resolution efforts?
Right. If they wanted to continue, then they can, work out the arrangements with that specific mediator, and they can continue on. And we're also expanding it to also mediators as well as neutral evaluators. But at this point, mostly mediators are on the roster.
Okay, so the first 4 hours sort of in court or by the court referral will be free, which is a savings and provides an opportunity to both parties. And attorneys are still free to use outside arbitrators or mediators, to use the Bar Association, to use other providers who've been out there. You just want to resolve the case to the satisfaction of each party and clear the court docket.
Exactly. I mean, this is something the parties have the opportunity even before they start litigation. I mean, I think the whole goal is for parties to realize that litigation is not the default, that it's not the only option to resolve in your case, and that, even before you come to file in your case, you can make use of an ADR professional. And a big step in that direction is that the statewide ADR office has created a statewide mediator directory on their website, and that allows litigants or prospective litigants to go and search and find an ADR provider in their area. They can see their credentials, their specialties, their years of experience, their training, and they can select, somebody to help them resolve the dispute even before they come into court. But the rosters are specific to an area type, and they provide, these mediators are trained, they're vetted, and they have agreed to provide this free initial session, which is a great resource for individuals who otherwise can't afford to make use of ADR.
If there's an experienced attorney out there listening and they would like to get involved in the process and become that mediator or arbitrator or neutral, is there an application process to the court or to you? Is there training that they can attend that's provided by the court system?
So the all roster, court-appointed rosters, mediators, and neutrals they have to be trained in compliance with Part 146 of the Chief Judge Rules. So Part 146 training is specific OCA-approved training, and it requires generally a mediator will have to do 40 hours of this OCA-approved training. 24 of those hours are just a basic mediation training, and then the additional 16 hours are in a more specialized area. So, for example, it could be commercial, it could be surrogates, it could be matrimonial, that they're getting that additional training. So those trainings are offered by specific providers throughout the year. It's on the court's website, has all the upcoming trainings, and it's good to kind of check back there and see what kind of upcoming trainings there are, because sometimes they fill up. You might want to contact one of the trainers to see if there's any type of opening. They can contact you. And that's on the court's website, the ADR website, which is nycourts.gov, and then you just go through to ADR.
But this training, the attorney will have to pay probably tuition for. It won't be a free CLE program or something along those lines.
Right. It is mostly paid, but we have recently, OCA does on occasion subsidize or offer the training completely without any cost. I mean, recently there was a surrogates training that was done, and there was no charge to the participants. I think there were approximately 30 participants that were court staff as well as practicing attorneys in Nassau and Suffolk County. So it's just kind of those opportunities come up here and there, and so you have to just kind of be on the lookout for it, and indicate your interest to the ADR coordinator in Suffolk and myself in Nassau, and so that we can kind of keep it on our radar if you are interested in getting in on those free trainings. And then there are also we work with the Nassau County Bar to try to put together programs that may be of a reduced cost. So those are things that kind of on need basis, they come and go. So it's not necessarily, there are opportunities for attorneys to not have to pay the full amount for the training.
But it may be a good investment for the attorney to take that advanced training. It will help them in their private practice and may open a new opportunity for them in addition to their practicing law. And it might be an important credential to their clients and to themselves to try to help resolve disputes in a positive, proactive way. I just want to remind our listeners that you're listening to Law You Should Know on 90.3 FM, the voice of Nassau Community College in Garden City, New York. Also, you can hear this program again, and we have podcasts of many past programs about the law, including some that provide an introduction to ADR and arbitration and mediation training. They will not qualify for the courses that were mentioned to you, but they will give you an overview and they will give you an introduction to some of the skills involved. And our guest is Yvonne Marin, and she is the ADR coordinator for the 10th Judicial District in Nassau County. What are some other, how's the role of the attorney from the court's perspective change in this age of ADR?
Well, when ADR is concerned, it's pretty much been established that the participation of an attorney can and will increase the likelihood that the case is going to settle. Either that's because they are able to help draw out important information, or maybe they're able to answer questions and explain the law so that the client really understands their position. So, there's a lot of reasons why the attorney's participation will help, but I think from the court's perspective, this is an attorney who is, representing a client who is participating in ADR. I think it's, from the beginning, even prior to the ADR session, it would be helpful for the attorney to participate in that selection process, if they can, of a mediator who is experienced in the area that they are, maybe has a special expertise in the area that's going to be mediated. And also oftentimes litigants have to provide a mediation statement in advance. So that's something where the attorney can help prepare this informative confidential memo for the neutral, and this will more efficiently make use of the time if the neutral has the important information up front, will tremendously help the neutral in developing options. So, a lot of time, if they go in and they're trying to pull this information, that's going to take a lot of time. And we have limited time on these court panels of only 3-4 hours. I think an attorney also should, in the beginning, educate their client as to what to expect in the process. And very importantly, to ensure that all the important stakeholders are actually present at the mediation. The attorney themselves, maybe a husband or spouse needs to be there that isn't, before this case can be resolved. Maybe there's a child or, an adult child that needs to be present. So if those parties aren't there, then, the mediation session isn't going to be successful. So that's something that should be discussed and explored with between the client and the attorney.
And if there's an insurance company involved or someone else who's in a position of authority, they should be participating in that mediation or ADR proceeding as well.
Well, I think that, I don't know if the insurance carriers themselves, but I know that it's important to have them available. If not, if they're not present and participating, definitely the clients need to be there, but to have people who have that decision-making authority available at the very minimum, yeah.
And usually as part of the process, there's a dialogue that will not take place in a trial. During a mediation, the parties may have concerns, and the mediator or the neutral can try to address those concerns. Maybe there's information that's needed. Maybe they want the mediator's evaluation on a certain legal issue or damages issue, or to clarify a few facts about the underlying event, or if it's an accident or the case law or something along those lines. So there's a lot more of those informal but important things can happen during the course of the mediation process.
Right. I mean, that's the key distinction, is that what's not going to happen in court, unfortunately, because of a variety of reasons, is that the client is not going to have an opportunity to air his or her grievances, is not going to have an opportunity to really vent to the court as to all the issues that may be behind the reason that they have filed their case in court today. And that's something that can take place in ADR. It can give the litigant the opportunity to hear the other side's position and understand better where they're coming from. And unfortunately, those are things that don't happen in court. Just right out of the bat, the client often, even if at a judicial settlement conference, the client is not going to be present at that settlement conference. If they are present, they may not have an opportunity to speak. And those are not the issues that are before the court. The court is not there to, get into all the questions of why do you feel that way, or why did this happen, or, what's behind that feeling, or what, that position. But the court has to deal with the legal issues that are presented and the cause of action and what supports the cause of action and how to determine, how to resolve the case. So it's a very different forum.
And in an ADR forum, it's going to be very informal, especially with mediation, where the client or the witness can tell their story and may not be subject to the rules of evidence, just so they can vent, just so the neutral and the other party can understand where they're coming from and the impact on them. And the mediator can hopefully fashion remedies accordingly, things that a judge might not be able to, or a jury might not be able to provide.
Exactly. Very often, the judge has very limited either it makes either it is or it isn't. There's no in between in terms of fashioning some sort of solution to this dispute. And there's a winner and there's a loser. And so sometimes that's not even what the parties want. That's not going to make them happy. And, it's not going to have going forward, the parties are going to end up back in the same situation because they don't have any sort of lasting agreement. So when the parties are able to create an agreement that them, together, that they believe satisfies all their interests, then it's something that's going to be more lasting, that they'll be able to live with and actually comply with going forward.
So I just want to add on that because the parties are participating in the resolution, they may be happier with the result on both sides. And it may be beyond a winner or loser. Sometimes through traditional adjudication in court, both sides are not happy with the outcome, maybe because of the law, maybe because of the facts, and appeals are very expensive. With ADR, the hope is both sides can be a winner. Both sides can live with and be happy and abide by the agreement. And the court, has the power to fashion a variety of remedies, to suggest them, and to alter them to the needs of the parties.
Right. So, there can be, the parties can bring a case to court, and all the court can do possibly would be to give them, a judgment. But what if that's not what the parties even want? What if the party wanted a return of something and then the other side wanted to, have their reputation remedied, so those are things that that you can't get out of a litigation, but you can develop this type of settlement in ADR. And
let's say it's a matrimonial case. Maybe there's, the neutral, the mediator might be able to fashion some type of compromise on the issues that's not available to judges in a strict trial.
Right, and something that the parties are going to cooperate with, and because they wouldn't agree to it if they didn't believe that it was a fair agreement.
And if they feel they're getting winning on some of issues of important to them, they're bound to be happier with the agreement and try to abide by it and to make it work, rather than something that's imposed by a judge or a jury. I'd like to remind our listeners that we're talking with Yvonne Marin. She is the ADR coordinator for the 10th Judicial District, which is Nassau County, and also court attorney referee. She also oversees the ADR program in Nassau County, and there are similar programs in the courts of New York City and the courts of Suffolk County, and attorneys can try to qualify to become neutrals recognized by the court system, and as one of the many things they can do, they can try to be an arbitrator or a mediator. What types of information do you have on your website, and will you have in 2021?
So the website, which is was a new development, we just got it up and running. It's just ADR focused, and some of the important things that we can find are a link to the statewide ADR page, and on that page there's great explanations as to all the different ADR processes and the differences between those processes, because I think it's important when parties are engaged. It's supposed to be ADR can also be appropriate dispute resolution. So the appropriateness is also part of picking the process. Which process is best for you? So it's good to know what the different processes are. Because arbitration, we talked a lot about mediation, but arbitration is also an option that maybe, if you're very close to settlement, that might be what could, really push you over to actually resolving. But also on the website, we have all the information about that Part 146 training and the rules, and upcoming trainings will be there. There's also further information about what presumptive ADR is. On our website, we have information on each of our district plans, within each court. So we have commercial, matrimonial, we have some programs in district. So there's a little information on those programs, but also all the forms that are necessary to participate in, to send a case, say, to matrimonial neutral evaluation. There's a special master program. So there on the website, you'll be able to find the order of reference, the rosters, the program rules. Also, you can find on the website some information on locating outside providers. I mentioned there's a statewide directory, but there's also community dispute resolution centers, which are an incredible resource to the community that they provide free mediation services for Nassau County. They have these 80 CDRCs throughout the state, and you can find one in your location. If you wanted to find one in Westchester or the city, you can go to the website and locate a CDRC in your area. But Nassau County, a non-lawyer can represent themselves, especially in the community dispute resolution, but the neutral is going to be a lot friendlier. It's not like the TV judge yelling at you and making fun of you. Exactly.
Now, under your plan, is the decision binding or non-binding on the parties, or they have both options?
Well, the only
Let's say of arbitration.
Yeah, well, in arbitration, the only arbitration we have right now in the court system is we have we have two arbitration programs. We have the fee dispute arbitration program, and we have in district court, there is a mandatory arbitration of civil matters. So in the district court, that is non-binding, so they do have a right to trial de novo, as well as in the fee dispute, as long as they haven't waived that right.
And do you have provisions where there can be a high-low agreement?
Well, that's something that could, that always before trial, the parties can discuss that and have that they can always make that agreement, or amongst themselves before trial.
So the court proceedings will allow for many options and flexibility depending on the needs and wishes of the parties.
Right. Yep. But the high-low, that comes in later. That's right before trial. So the goal is at this point is to have these cases resolved long before then.
So what are what other information would you like to convey to the attorneys out there who need their disputes resolved that may have been slowed down or frozen by COVID? Or what other messages would you like to give to litigants out there and the general public?
Well, I think it's the opportunity to address their issue in ADR may not always lead to resolution. It may not always lead to a complete resolution of the case, but there's a lot that they can get out of the process, and it still would be success. We talked about the fact of being heard. So that just gives an opportunity, even if your case isn't resolved, you may walk away in such a better position that going forward in your case in litigation that, things are going to be able to go a lot smoother, and maybe down the road, you're going to be able to come to a resolution. And then also that you can settle some issues can be settled. It doesn't mean you have to settle all of the issues. In a matrimonial case, there could be the issue of financial issues. There can be custody issues, visitation issues. So if you can take some of those issues off the table, then it's a success. So I think, there's a lot of reasons why ADR should just be just given an option, given an opportunity. And then going forward, maybe this is, you have a good experience in one ADR session, and then you become to realize that this is something that you should try on other cases.
And this could be the wave of the future, even in non-COVID related situations.
Exactly. That was the goal. This started before COVID even came about. So it was something, and it's across the country. Other states have programs and statutory requirements in which ADR is required even before the case comes to court. So that's the direction it seems a lot of jurisdictions are moving.
I'd like to thank our guest, Yvonne Marin, the ADR coordinator of the 10th Judicial District, and also a court attorney referee.
Thank you so much.
If you've missed any part of this program or you want to tell someone else about it, the podcast is available at nccradio.org. Many other programs about alternate dispute resolution and other legal topics are also available at nccradio.org as podcast. And please join us at this same time next week on 90.3 WHPC for another program on Law You Should Know.